Writing in the dissent for the Supreme Court ruling that struck down Doma, Antonin Scalia got a little bit feisty, and he had a problem with certain aspects of what happened here. And so we're gonna spotlight a couple of his quotes and break them down and see if there's any intellectual merit to what he's saying. So the first comment from Scalia is, "We have no power to decide this case, and even if we did, we have no power under the Constitution to invalidate this democratically adopted legislation. The court's errors on both points spring forth from the same diseased root. An exalted conception of the role of the institution in America. The court is eager, hungry, to tell everyone its view of the legal question at the heart of this case." And tied in with this is another comment that he made. He said that it's jaw-dropping. "It is an assertion of judicial supremacy over the people's representatives in Congress and the executive. The framers of the Constitution created a judicial branch with limited power in order to guard their right to self-rule against the black-robed supremacy that today's majority finds so attractive." And so what Antonin Scalia is saying there, and this would seem to be fitting with his judicial philosophy, is that the Supreme Court is supposed to have a very weak power. It's not supposed to be throwing its weight around, for instance. And you could even extrapolate from what he's saying there that he doesn't believe that Marbury versus Madison should have happened, or the interpretation of the court's power coming out of Marbury versus Madison should have happened. So it would seem that he's totally against judicial activism there. And look, we like to at times point out hypocrisy in the political figures that we cover. And so maybe if we were to go back years, perhaps even decades, we could find examples of Antonin Scalia engaging in a bit of judicial activism. Or maybe we could go back about 24 hours when he struck down part of the Voting Rights Act, voting in the majority, to eliminate protections for minority voting in America. That is nothing but a case of judicial activism there. And so we don't even have to go back to the weekend to find an example of it. Another case of judicial activism that Antonin Scalia engaged in. I don't suppose you remember a little case called Bush v. Gore? He got a little bit active there. And it had pretty strong consequences, I would say, for the country. Even 13 years later, very strong consequences. Let's move on to his next comment. Antonin Scalia says, "As I have said, the real rationale of today's opinion, whatever disappearing trail of its legalistic argle-bargle one chooses to follow, is that Doma is motivated by bare desire to harm couples in same-sex marriages." And so what's interesting there is that he has a problem with the fact that we are, I suppose, creating a straw man version of what the opposition to same-sex marriage is, as if it's a very simple thing. But it is, in the end, a very simple thing. Now, they will occasionally throw up concern for the children or something like that. Those studies inevitably get destroyed. The children in same-sex couples do at least as well, in some cases better than couples brought up in opposite-sex marriages. And so when you get rid of all that stuff, I think that it is about as simple an argument as it can be. And you don't need to take, an encyclopedic length tract to explain what the people with the opposition to same-sex marriage think. You don't even need to do something as long as, say, a Harry Potter novel or something. I think they can be really struck down to just 3 letters. EWW. Ew. They have a moral opposition or a biological opposition to the sex underlying some of these marriages. They don't like it. Okay, and for one thing, Scalia there, now he wants to make it seem as if there's these deep philosophical reasons that they're opposed to same-sex marriage, but if you were watching the news, his other comments outside of this minority opinion, he was talking nonstop about homosexual sodomy, just sodomy this and sodomy that. He wasn't so concerned about states' rights when he was giving his opinion today. It was mostly about the physical aspects of what was going on here. And so I had a problem with that. Moving on to his next comment. "I find it wryly amusing that the majority seeks to dismiss the requirement of party adverseness as nothing more than a prudential aspect of the sole Article 3 requirement of standing." Going on, "As I have observed before, the Constitution does not forbid the government to enforce traditional moral and sexual norms. However, even setting aside traditional moral disapproval of same-sex marriage, or indeed same-sex sex, there are many perfectly valid, indeed downright boring, justifying rationales for this legislation. Their existence ought to be the end of this case." Now, I love that. So he says there that there's nothing in the Constitution whatsoever that says that the government can't enforce its view of traditional morality or sexual behavior. And what I like about that is if there's nothing in the Constitution that stops a traditional morality from being enforced, there's apparently nothing stopping an evolving or progressive morality from being enforced. And so if you can protect the way that people viewed homosexuals 175 years ago, I don't see why you can't protect the view that we have of homosexuals today. And it's a little bit more progressive than they had back when they were wearing the white wigs and had wooden teeth. And so I love that he gave a little bit of ammunition to our side there, perhaps without intending it. I already talked about the other rationales for the legislation. He'll probably cite something about domestic abuse or bringing up children or the educational effects or something like that. But we saw when Prop 8 was being argued, when the appeal that would eventually lead to the banning of Prop 8 was appealed, the science is simply not on their side. He says, "Some will rejoice in today's decision and some will despair at it. That is the nature of a controversy that matters so much to so many. But the court has cheated both sides, robbing the winners of an honest victory and the losers of the peace that comes from a fair defeat. We owed both of them better. I dissent." He wraps it up nicely there at the end, and I suppose in some legalistic sense, some philosophic sense, yes, the winners and losers in this case have been robbed of something. And perhaps if the case had been argued and the ruling had been argued in a slightly different way, it would be satisfying in some philosophical or legal sense. Now, I suppose for the winners in this case, they're just going to have to take at least some solace, some consolation from the fact that although they don't have the philosophical underpinning that they wanted, they can now, after years or decades of conflict, finally marry the person that they're in love with.